Hundreds of thousands of researchers around the world are working to improve life and address imminent threats to humanity. Often their research ends up in the scientific valley of death in the form of publications and patents that never see the light of day. That is about to change. Welcome to the Lab to Startup podcast, hosted by Naresh Sunkara, founder and executive director of the Berkeley Postdoc Entrepreneurship Program at the University of California, Berkeley. This show has two main goals: share the stories of those who have successfully founded startups based on their own research, and highlight resources needed to help those aspiring to launch startups in the deep tech space. Whether it's electric cars, vaccines, addressing climate change concerns, or possibly establishing life on other planets, Naresh and his esteemed guests want to help scientists, engineers, faculty, and researchers bring their innovations to market. Learn more and subscribe today at labtostartup.com. And now, here's Naresh.
I have two very special guests on my show today, Nick Dorsey and Amanda Gold, both partners at Cravath. Cravath has been known as one of the premier law firms in the US for more than 2 centuries. In June 2022, Cravath was ranked number 1 on Walt Law 100, a ranking of the most prestigious law firms across the United States for the 7th consecutive year. Nick dedicates a significant portion of his practice to providing commercial and strategic advice to startups, early stage and founder-led companies, and investors in such companies. Clients regularly seek his counsel for the practical commercial advice he offers with respect to their most challenging matters. Amanda focuses her practice on executive compensation matters, including designing, drafting, and negotiating severance, change in control and executive employment agreements, and managing all executive compensation and employee benefit aspects of public and private mergers and acquisitions. She also frequently designs and provides practical advice on the administration of equity incentive plans and complex awards for private and public clients. You can find a link to their bios to learn more about their practice areas in the show notes. In this episode of Lab to Startup, we will discuss a wide variety of topics involving legal aspects for startups from incorporation to exit, with a focus on 2 subjects: dilution of equity and safeguarding founder and employee equity. These subjects are not really well understood by founders, and hence the focus. I also want this to be a primer on legal aspects for aspiring founders and also early stage founders listening to this podcast. I was introduced to Nick and Amanda by a dear friend of mine, Nathan No, who used to work with me in the lab at UC Berkeley and is now at Cravath. I hope you find this conversation very useful.
This interview is intended to provide general information only. It should not be relied upon as legal advice, as facts and circumstances may vary. The views expressed are those of the interviewees and do not reflect the views of Cravath, Swaine, and Moore LLP, hereafter referred to as Cravath.
All right, Amanda, Nick, welcome to the show. I'm super honored to have you both from the most prestigious law firm in the US. And I've been thinking a lot about this conversation we're going to have today. And the fundamental premise for requesting you two as guests on my pod is that there is legal illiteracy amongst founders, and especially amongst those like me who have been neck deep in researching a problem during my PhD and postdoc training and now trying to build a startup. And most of us have never been exposed to legal aspects of pretty much anything in life. So I want this conversation to be Legal 101 for deep tech startup founders. Let's start with the basics and then deep dive into topics that might seem hard to understand. And I also want to deep dive into the subject of dilution for founders, as well as safeguarding the employees at these startups, because most people don't understand this. If you guys are okay, we'll get started. And Nick, maybe you can start.
Yeah, I'd be happy to.
If someone is trying to build a startup, what should they start thinking about as their first step?
So I think a primary step in getting going as a startup is thinking about entity formation. And I think a lot of startups are familiar with the idea of, I need to form an entity, right? But they may not know, why might I think about an LLC? Why might I think about a corporation? And what am I trying to achieve? And I think the primary purpose of entity formation is really to try to achieve the concept of limited liability. So limited liability is the basic idea that when you are a founder and you're starting your business and you're putting in capital, you are at risk for your investment, so your time as well as the money that you put in, and other owners are similarly at risk for that invested capital, but they're not at risk for their personal wealth, for their home, their checking account, and the like. And so as you begin to transition from scientist or researcher into entrepreneur and startup founder, you want to think about forming an entity that you can then use to conduct business. And then I think a related question or a follow-on question is what form might make sense? It probably is worth spending just a minute or two on the key different forms that startups can take. One form is a limited liability company, an LLC, and this is a very common form. It's a straightforward entity type that an individual can choose to form. You can have just a single person owner, single person operator for that business. And one of the key benefits that makes it easy to administer and also to think about from a tax perspective is an LLC is a pass-through entity. And so what that means is if you're a business owner and you're generating income, it's not the LLC that pays tax, it passes through to you as the owner. So that's a pretty attractive feature. For those that are doing a little bit deeper dive, you have some opportunities to explore some enhanced features to an LLC, which I'll just mention briefly. You have the ability to explore what's called an S Corp, which is the ability to opt into some features that are akin to a corporation, like issuing shares and having the benefit of that, but still maintaining that pass-through status. And then the third option is a traditional corporation, a C corporation. And there you have the ability to issue shares, which investors, whether they're friends and family or future investors, are very familiar with. But there are some potential adverse consequences early on, including planning for potential taxation. And so I think that's an early thing to think about. No particular form is best for every startup, but it's something you want to think about. And entrepreneurs can understand that you have the ability to move, for example, from an LLC to additional C Corp. But that really gets the ball rolling. It allows you to start your business. And at that point in time, you're not really worried about dilution, which I know we're going to have a chance to speak about a lot today. But it's really just getting the ball rolling so you can protect yourself and set the business up for success.
That's very refreshing because I think this is the first time I'm hearing a law firm say that, because in the Bay Area, they're like C Corp, C Corp, C Corp, C Corp. And especially if you're a deep tech founder where your path to market is so long and you're not ready for venture funding anyways, and this is the investor's talk, I guess, that it has to be a C Corp. And how hard is it to move from an LLC or a S Corp to some other form? Maybe you can shed some light on that.
So it's fairly straightforward to transition with appropriate planning from an LLC to a C Corp. One option is just to do a straightforward conversion. So at point A in time, it's an LLC, and point B in time, it becomes a corp, and you file the necessary paperwork and make the necessary tax elections. There are more complicated structures that can be involved. One structure, which I'll mention just for listeners so they are familiar with the term, is called an Up-C structure. So at a very high level, an Up-C structure involves having the operating business be contained within an LLC. And that LLC then is owned in part by a C corporation. And I'm overgeneralizing here, but basically new investors who are coming in can invest at that corporation level. So you think about venture capital funds, or even down the road, if the company goes public, your other outside investors hold shares in a C Corp. But you have some of the management or founder owners down at the LLC. And that structure can have some benefits, including from a tax structuring perspective. So the upshot is you have flexibility to move from an LLC to a C Corp. And really what I encourage listeners to do is to think about what makes sense for me now, recognizing my business goals, my budgetary constraints, my tax planning, and solve for that in the near future, and then grow the business, and then look for opportunities to potentially change the structure in an optimized way at a future point.
Wow. Yeah, I didn't know that. Amanda, probably should go more basic of like, how does one pick a law firm? There are so many of them, and what should a founder look for in picking a good one? And maybe I also will add some more context, because most of the listeners are in the deep tech space, like in a diagnostic or therapeutic and so on. And in most of the cases, what happens is they get acquired. A few go to the IPOs, but then they're going to be acquired by a bigger company because they cannot survive by themselves. So with that as the context, with the future of exit, we'll go into this topic a little more. How should one pick a law firm?
Good question. I think you hit on an important point about the exit. I think choosing the law firm should be somewhat future looking, not a lot of the initial documentation, particularly on the equity comp side, which I focus on. You want to keep it market. There's not necessarily a lot of magic to, for example, a stock option plan at the early stages of a company. Where things become very bespoke, where you need expertise, is later on, Series C, an IPO and exit transaction. So I think it's important to focus on that early on because it's hard to switch midstream.
I also think, I agree with that. I also think that just like the entrepreneur is investing in him or herself and friends and family are putting in capital, I also think that the company wants to invest in itself and set itself up for success in the future. And I think finding a law firm or other partner could not necessarily legal services, but other services that the company may need, right? Finding a partner who's willing to be creative in terms of approaches to really be able to grow with the company is a good fit. And ultimately, I would also say it's really important that the entrepreneur finds individual lawyers that they really find that they get along with. Because just like any other line of business, a lot of organizations have great names, great people, but who are you going to be working with? And do you have the right rapport? And I think that's important too. And so you're finding the right person who's specifically going to help you grow your business, I think is really important.
Yeah, that's a very valid point. And one other problem I come across is some law firms say they're really good with their intellectual property abilities, and some others are great on corporate front. Like, how does one look at these things? Because you're working with one law firm. Is there room for picking different partners, or is that a bad strategy? How should one think about it?
From my perspective, I think it is certainly possible. In some cases, it makes a lot of sense to work with a couple different law firms. You don't want to stretch yourself too thin where you have a dozen different law firms and it's very hard to coordinate, or that coordination falls on the entrepreneur. But I think there are areas where having a couple specialist firms can be very helpful, and it can vary by the business, but perhaps a law firm, that's more focused on regulatory matters. So if the business is in life sciences and needs to consider FDA matters or other matters, if the business is more has applications to space and technology, and there may be potential government applications of the technology, having a firm that can provide some specific expertise on the government areas, because I think it can be hard to find the exact firm that solves everything. But being pragmatic, and I think what is helpful is to have one primary counsel, I'll just call them corporate counsel, that helps the company grow, think about matters like the corporate things we're talking about today, the executive comp things we're talking about today. And those law firms, as an entrepreneur, you should expect that firm to be able to point you in the right direction when it makes sense for a referral. And so I think you as the entrepreneur shouldn't feel like you need to decide everything. You should feel open and asking my law firm, hey, is this the kind of thing that makes sense for you to work on or not? And can you give me a referral? And I think you'll be surprised that the law firms at least try to be very open. We try to be very open on areas we can add a lot of value and where someone else is a better fit.
Nick, I would add to that. I've seen mistakes, again, in my narrow area of equity comp, for example, in the telemedicine space. Highly regulated. Some of those regulations significantly impact the way the equity compensation is structured, who it can be granted to, how it can be granted. So you may have an expert in equity comp. If that expert does not understand the regulatory overlay to that unique business, there's going to be some potential problems to unwind down the road, and better to avoid that at the front end.
Yeah. And does the onus fall on the founders here to talk to the law firm, or are the law firms being upfront and saying, hey, you might want to consider these other law firms? Like, how does it actually work in the real world?
Well, it's hard to take a position on other firms, but we certainly pride ourselves on identifying for clients when we can add a lot of expertise, which is very often the case, but also when there are others who can add particular knowledge. I guess to maybe answer your question in a more general way, I would encourage entrepreneurs and startup founders, when you're getting started and you're thinking about a firm, or when you have a natural pivot point, you've grown significantly and maybe you've outgrown an initial firm, as part of your discussion with a potential law firm that you're looking to hire, I think that's a great question to ask them. For example, I'd love to hear what are the areas that your firm has expertise in, but also can you give me some examples of areas where you might be able to make me a referral to a firm that can service a particular need for my particular business, and firms that can really answer that well and identify their strengths, but also identify where someone else can help, I think is often a good fit for that founder.
That's great advice. Nick, I'd like to get clarity on a few terms, which I didn't understand when I was incorporating my first startup. Maybe you can shed some light on what the founders need to know about these terms, like the corporate charter, bylaws, and the shareholders agreement.
Sure. So a prelim point, cap gains versus ordinary income rates. drives much of what I do in the compensation space. Tax rates vary, but generally ordinary income, when you add in federal tax, state tax, particularly in states like New York and California, call that 50% more or less is going to the government in taxes. That's at ordinary income rates. Capital gains rates, much lower, hovering around, call it 20%. So there's huge incentive to structure an equity award to achieve that capital gains treatment. Restricted stock, which you've heard of in the context of the 83B election, restricted stock, generally that's what is issued to founders, very early employees, or perhaps some of the advisors that Nick was just speaking about. It's referred to as restricted because of the vesting schedule. And the tax code allows this instrument called an 83B election, which effectively truncates the ordinary income component of the award. So that higher tax rate truncates that very early on, making all further gain capital gain. So very, very attractive. You might acquire the shares when they're worth a penny. You make this 83B election, you later sell at $10 a share, the $9.99 would be eligible for the lower cap gain rates in that scenario. Key thing to remember, as you know, with the 83B election, you have 30 days to file it with the IRS from the receipt of the stock. That deadline can't be moved. Very, very difficult to fix a missed 83B election without some pretty ugly economic consequences. So when I talk about equity comp, when I give these presentations, that's usually one of my top 3 takeaways is to file that 83B election on time within the 30 days.
Thank you for plugging that in. Before we move on to the next topic, I want to touch upon 83B and capital gains, and something I had no idea. And then my lawyer said, this is the last day you need to send it in. And can you talk more about that?
Absolutely. So the charter is the main document that actually forms the entity in the state of incorporation in the case of a corporation, or the state of formation in the case of an LLC. So it's a very short document, includes things like the name of the entity, right? The person who's actually forming or incorporating the entity. In the case of a corporation, it'll identify the authorized share capital, but it's a very basic form. We're talking about 1 page, 2 pages, potentially a few pages longer, depending on the form people are using. And that really gets the business formed and allows for the entrepreneur to begin to operate the business with that benefit of limited liability that we touched upon before. Then there's a document called the bylaws. And the bylaws are a slightly longer document. And the bylaws include various other provisions that relate to the workings of the company. So things like, who are the initial directors and how do we appoint them on a go-forward basis? Potentially, how do directors get removed? What are the procedures for having a shareholder or owner vote over a particular matter? Those types of more operational matters. The bylaws, unlike the charter, are not filed with the state. So you have a bit more privacy with respect to the inner workings in the bylaw. And then you have the shareholders agreement, which is quite common. The shareholders agreement really is the document, as the name suggests, that governs the relationship among the shareholders, and in certain cases, the relationship between the shareholders and the company itself. And I think particularly for listeners who are looking to start up a business and are looking to have early investors or potentially have a co-founder, you want to focus on this agreement. If you are finding yourself in a situation where you have a co-founder, or maybe not necessarily even a true co-founder, but someone who's very closely tied to the business, maybe has particular operational expertise or research expertise, and you really view them as a core start up to the business alongside you, you want to think about, first, as a commercial matter, what are my goals as the founder and what are the goals of my co-founder? Do we both try to exploit this opportunity to the fullest potential until we ultimately sell the business? Or alternatively, are we trying to explore this venture for 1 to 2 years before we pursue other ventures or other opportunities? And maybe those goals are the same between founders. Maybe they're different. Things like, is everyone putting in the same amount of cash capital? Maybe some people are contributing intellectual capital, intellectual property, or labor, and not necessarily cash capital. And you have to think about how you allocate rights and responsibilities between the different co-founders. So for the shareholders agreement, it is an agreement that governs the rights among shareholders. But in particular, for a startup, it's an important document to focus on with your co-founder or your early owners so that you can identify any issues and try to have a clear understanding. General recommendation, although some of these conversations can be difficult, like to your co-founder, how long do you plan to stay in this business? That can be a difficult conversation. As a general matter, it's much better for everyone involved, as well as the company, to try to have those conversations early so that you can try to plan for that as much as possible and avoid unintended consequences, particularly later down the road when hopefully the business is successful, it's got employees, and having a fight between co-founders that doesn't have a document path to resolution can be quite challenging. The last thing I'll say about the shareholders agreement, as the company grows and begins to get outside capital, so not necessarily a friend and family who comes in, but maybe you have your future round of capital, maybe a seed round or a Series A round, which we'll probably have a chance to talk about later. Then you begin to have various other rights that can be enshrined in this document. Things like, are there certain instances of corporate action like incurring debt or acquiring a business or changing the focus of the business that require not only the founders sign off or the board sign up, but potentially one or more of the key shareholders. And so those kinds of rights are also enshrined in a shareholders agreement.
Thank you for that. And I want to go down the shareholders and equity and so on, but thank you for filling in that information. Let's go back to something we're talking about in terms of equity splitting. This is a tough topic to bring up with co-founders and who owns what. Recently, I was talking to a professor who said, let's split the equity between the three of us, 33, 33, 33. With that as a context, can you help us understand issues about equity and how one should think about as not just short-term, but long-term?
For sure. Maybe I can take the first cut at that. So in terms of the initial division of equity between founders, I think it's important for the founders to have that conversation and to be honest about their relative contributions. And the answer may be obvious. It may be a 50-50 or one-third split, or it may be that someone is coming later to the party that brings a lot of expertise, but maybe hasn't been running at it the whole time. And so having those discussions is good. It isn't always the right answer that you take the number of people and each gets an equal share. I would also say, going back briefly to an earlier point about individuals' expectations and goals for the business and how long they intend to stay, one thing to bear in mind is that a lot of startups, particularly when they're doing a seed round or a series financing, sort of their early round financing with outside capital, but even some before they bring in that kind of outside capital, are beginning to think about a vesting schedule. And Amanda can chime in here too, but at a high level, a vesting schedule is a concept that even if all of the equity, and I say all, I mean that loosely, it may be all between the two founders, setting aside an outside capital provider, but the capital held by one or more founders, it may be set up initially where it's essentially all of their equity, but there's an incentive between the founders and also as between the founders and outside capital to stick around. And it's basically a concept where some portion of the equity is truly outright owned fully and clearly by the founders. And then the remainder is essentially earned over a period of time. So maybe 25% upfront is essentially owned by the founders. And then over the succeeding 4 years, an additional percentage is becoming theirs. And so that can also help in some ways solve the discussion between founders as to what is my share and what is your share, particularly if there's concern that one founder may be more likely to stick it out for the long term. In some ways, that may help correct itself just by virtue of a vesting schedule. And that could be a reason why founders discuss among themselves a vesting schedule that is fair, even before an outside investor might think about that. But Amanda, you see a lot of that in the context of founder equity as well as key management equity. Maybe you want to talk a little bit about vesting.
Sure. On the very typical vesting schedule, certainly in the West Coast Bay Area space in particular, a 1-year cliff with monthly vesting over the following 3 years. So a 4-year vesting schedule in total. As Nick said, it helps because I've seen a lot of situations, and we alluded to this a few moments ago. You're 2 years in, two founders, someone pivots, someone isn't devoting the time that was anticipated. They want to take on a different role. They want to leave the business. It is, at least in a technical sense, easier to unwind at that point when a portion of the equity is unvested. Again, meaning if that person leaves, the unvested portion is simply forfeited. As a practical matter, it doesn't need to be repurchased. It just evaporates. And again, it can simplify the breakup, and those do happen.
One other thing I might add on that, as between founders, there are other rights and discussions that can be had between the founders to try to solve for these kinds of issues. For example, separate from vesting, it might be that there's an arrangement between the two founders that if one wants to either leave the business or wants to sell down a portion of his or her stake, that the other founder has an opportunity to purchase those securities. Now, obviously, that has some complications, particularly for startups as the business grows in value, whether the other founder will actually have quick access to cash to purchase it. That's something to be considered. But nonetheless, it is an option that exists. Other options like a right of first refusal. So if one founder has decided to sell a portion of his or hers, the other person gets a final look. So there are different rights that can be discussed. But unfortunately, this is an area where there really does need to be that difficult conversation between founders. So the lawyer's role, really, what we try to do is help people understand the difficult questions to ask themselves and their co-founders and help identify different ways to resolve contentious issues. But there's not a clear path from market practice or legal practice that dictates an answer in each situation.
Great points. And maybe if you have an example, because what I hear mostly in startup space is that your expertise as founder may not be good enough after 3 or 4 years, and you might need to bring on some other people. I know vesting is great, but what precautions can founders take to facilitate that conversation ahead of time? How would that look like? And if you have a story of a startup that did it well?
So I've worked with companies before in that kind of situation. And I think one of the things that has helped the founders in those businesses is to think about what additional rights to control the business, in addition to equity. We're talking a lot about equity, but in addition to equity, what rights can they ensure that they enjoy as the business grows? So they believe they continue to have significant exercise of control over the business, even if other people are coming in and making certain decisions. So I'll give you a couple examples. One example is a list of certain actions that would require the particular founder's consent. So even if it is a situation where the founder has been very successful growing the business for 3 or 4 years, but the founder has decided, or outside investors in the business at that time have decided it's now appropriate for someone with more what I'll call professional CEO experience, professional CFO experience to step in, that founder doesn't feel like the business is moving away from him or her because certain actions like changing the strategic vision, entering into really critical partnership agreements still require their consent. So that's one option. Another is to think about fairly early on how the founder can surround him or herself with knowledgeable, value-added people, but who share a similar vision as some type of advisor or board capacity. And I say that loosely because depending on the form, LLC, corporation, et cetera, the particular title may vary, but the basic idea is as the business grows, you would envision more and more decisions being taken by consensus from key board members or other key decision makers as opposed to a single point of contact. And as outside capital comes in, whatever that governing body is, it's common for those investors to want to have a seat at the table. But if the founder has early on surrounded him or herself with people who share that vision, then to use an example, when that company's doing their Series A round, Series B round, and the investor says, hey, we'd really like to see some professional CEO experience, that person comes in, that person's on the board, but there are already 3 or 4 what I'll call friendly faces around the boardroom that can help ensure that vision. So I think those are a couple things to think about.
Maybe that's a nice segue to talk about hiring your first employees or consultants and bring on advisors. Can you please provide some guidance on hiring and creating the right incentive structures using equity?
Sure. Again, I think of the awards on a spectrum of type of award, talking now about a corporate structure, not an LLC, which is economics might be the same, but the types of awards are generally different. Typically start out with restricted stock, again, founders, maybe some very early employees. Once you start hiring more employees, there's no magic number, but maybe employee 6, employee 10, usually we'll see a shift to stock options. And there's a pool set aside for that. Nick, I don't know what you see. People will say 10%,
10 to 15%.
10 to 15% of the company's total equity, sometimes a little bit lower, sometimes a little bit higher. That is set aside for equity awards to employees. And I know we want to talk about dilution at some point here. Very important to manage that pool, because once that pool, let's call it 10%, once that's granted and issued to employees, and you have more employees you need to issue equity to, someone's getting diluted, most likely, to make those additional awards. So, really important to manage it. And it's difficult. There's no benchmark that says an engineer should receive 100 stock options or 0.01% of the company. There are surveys exist. I find them not particularly helpful. So really important to get those numbers correct, to do some future planning. And that's where these advisors can be very helpful to sizing the equity awards.
I'm guessing in all of this, I think the law firms actually know a lot more than the founders here, and they're going to be guiding them in terms of what this restricted stock is going to be and allocating and dilution. Who is a good advisor for these topics? Who should somebody turn to?
Generally, it's the law firm, particularly early stage. You're not spending your money hiring a compensation consultant like a public company would or a very mature startup would. So most often the law firm has a good sense of market data. We're not compensation consultants, but we usually have a good sense of market. And these other advisors, the advisors Nick mentioned, surrounding yourself with these friendly faces, often they have other startup experience and a good sense of what's appropriate for this sizing.
In my experience, maybe you share this as well, Amanda, I think where we could be most helpful to founders who are thinking about how to size the award is when we have a conversation about what they're actually doing and what kind of value they bring and what the goals are. I think in a vacuum, just to receive an email and say, I'd like to hire an engineer, to your example, Amanda, it's hard to respond to that.
Right.
But having that conversation, we can actually add a lot of value. And actually, that's really one of the things that both of us really enjoy about this kind of work, right? Is having that conversation to understand how the business can grow. And that includes bringing in top talent.
Yeah. The reason I'm trying to bring up this point is that I think the founder should keep in mind that lawyers are your friends and make sure you get the right advice from them and not see that as the last option. And before we go forward, I just want to get some clarity on what RSUs are, restricted stock is, and options is.
Sure. So I spoke a moment ago about this spectrum of awards. So again, we usually start with restricted stock. Those are actual shares of stock. They might be vested or unvested. Actual shares of stock, all rights of a stockholder attached to those. There are voting rights to dividends, if any dividend would be paid, inspection rights, and the like. Some, as Nick said, some ability to contract around some of that. One person might have additional voting rights, but those are real shares of stock. A stock option is a contract. It's a piece of paper, not real stock. Contract to acquire stock in the future, usually following vesting and subject to payment of an exercise price. So you have to write a check to acquire the shares. Often there's a tax event at the time that you write the check to acquire the shares. And that's a whole other conversation about liquidity. You're a private company. Where is the money coming from to pay the exercise price, to pay the tax? And that's again, probably a topic for another session, but that's a real concern for a lot of startups. A restricted stock unit, then that's usually the type of award that occurs somewhat later in the life cycle when options have become cumbersome due to valuation and or dilution concerns. A restricted stock unit or RSU, that's also a contract to acquire actual shares in the future. Usually the shares are acquired at vesting. The tax event also occurs at vesting. Unlike an option, the employee, the holder of the RSU, there's not this optionality. I can exercise at year 3, or I might wait until a liquidity event to exercise the option. The RSU The shares underlying that RSU, those are delivered on a fixed date. The tax typically occurs on a fixed date. Again, speaking of liquidity concerns, it's a big problem. I've had many clients, they're facing, it could be a $400,000, $500,000 tax bill if the company has done well. Again, private company, you can't sell these shares into the market to cover the tax bill. It's a difficult issue and something good counsel can help plan around.
Great. Thank you for explaining those things. I think RSU is a whole different subject we can touch upon some other time. But
Yes.
let's go with the basics. One thing is at the early stage of a startup, maybe you don't have enough money and you're trying to hire a contractor, consultant. What are the best ways to compensate those people?
Usually it's with stock options. Consultant advisor might be different. There's always some salary. It's usually lower than what one might see in certainly a public company or a very mature private company. But stock options or in later stages, the RSUs are often the bulk of the compensation, particularly for the advisors. Usually I don't see them taking any type of fee or retainer, and it's an equity award only.
Yeah, more like options, you still have to buy those things, right?
You do, yes.
Yeah, but if somebody is actually performing the work and you don't have the money, and can we grant them some stock without them paying any money as a compensation?
Sure. They don't pay for the stock options up front. So
Okay.
it's a grant of a contractual right, as we said. Nothing's paid up front. There's no payment until the holder, the employer, the advisor chooses to exercise. What we often see, and there's good data on this out there, folks hold their options until a liquidity event. Again, if you have to pay for the option, there might be a very large tax bill. It often is more beneficial to hold on to the contract than usually if and when a liquidity event occurs, those options are cashed out and taxed at that time. So there's no cash outlay until there's a guarantee of payment.
Thanks for clarifying that. Maybe we should shift the gears and talk about fundraising. At the early stages of startups, it's mostly friends, family, and angel investors. And most of these people are not sophisticated. And the investment world has these tools called convertible notes, safes. And I had a tough time explaining some of my friends what these notes are. Like, I'm not buying an equity, and like delve us into these topics and
Yeah, no, I'd be happy to talk about that for a little bit. So when we think about early investing, we're often thinking about the term seed investing, which is we're talking about friends, family, other small angel investors. And in terms of order of magnitude, we're probably talking about $100,000 to maybe $2 million in sort of overall capital raise. So it gives directionally what we're talking about for these kinds of instruments. There are two primary types of investment vehicles that are used. There could be others. The first is a SAFE, and SAFE is an acronym, SAFE, for the Simple Agreement for Future Equity. And this is an investment that is stock-like, but doesn't have the traditional rights associated with stock. So what I mean by that is if someone puts in $100,000 as an investment in the form of a SAFE, they don't immediately receive shares of the company. So they don't have any voting rights, dividend rights, et cetera. They have a promise, a contract by the company to receive shares at a future point in time when certain conditions are satisfied. So some of the attractive features of this type of investment from the founder's perspective, there's not a maturity date. It doesn't accrue interest. And you have some flexibility into how that investment converts into equity. And we'll talk about that. But so if you think about relative to a loan or debt-like instrument having no fixed maturity date, not needing to accrue interest, that's pretty attractive from the perspective of the entrepreneur and the startup. A convertible note is a debt instrument. So it's similar to a loan that you might get from a bank, right, where you have to repay at a specified date if you haven't otherwise repaid it before then. And it has an interest rate accruing, very often a fixed interest rate. But as the name suggests, convertible debt, it converts into equity in certain situations, primarily linked to a subsequent financing. It could also eventually convert at a future event like a sale of the company. But more realistically for this type of company, what we're talking about is it converts when the company does its first institutional round, like a Series A round. So maybe circling back just for a second on the SAFE, I'll talk about the two primary ways that founders think about the economics behind that. The basic principle is that the amount of money, well, again, in this example, let's say it's $100,000 that's invested, is going to be converted into shares of the company. One is to negotiate and agree with the investor what's referred to as the valuation cap. And the valuation cap is a specified amount that the investor agrees and the company agrees that if the valuation exceeds that amount when the institutional round occurs, the conversion will nevertheless occur at that cap. So let me use a concrete example. Investor puts in $100,000 and there's a valuation cap of $10 million in this example. If there is an institutional round that follows that SAFE at a $7 million valuation of the business, then the conversion will occur through the math in the document at a $7 million value. So it's essentially similar to the investor who would put money in the SAFE participating in that institutional round. If the valuation of the company in that institutional round is $10 million, which is equal to our cap, same outcome, converts at about $10 million valuation. If instead the valuation of the company is $12 million at the time of that institutional raise, then the SAFE will nonetheless convert at $10 million. And so that's a little bit of a benefit to the SAFE holder, right? And a little bit of extra dilution to the founder and those any other earlier investors. And that's okay. That's an economic term that can be negotiated, something to be mindful of as you're thinking about dilution as a founder. But it's essentially the idea that if someone puts in money early and the business exceeds the value that the founder and investor anticipated, then that's okay. And the last thing I'll say about this point before going to the other way to calculate the conversion, I generally suggest that founders not be overly concerned around the valuation cap and think about what would be reasonable and get some data points from your lawyers or other advisors, because it's really, really hard for an early stage company to think about value. You don't have clear comps to draw upon like you would in other businesses. And so there's that point, and also the difference between a $10 million, $12 million, $14 million. When you're talking about a raise in the range of, as I said, $100,000 to $2 million, you often want to take the money that's available to you, do a good job negotiating, but grow the business and not fight over, in the scheme of things of your business, relatively small dollars. So it's an important point, but don't lose too much sleep on it. As it relates to the other approach, it's referred to as the discount approach. The discount approach, as the name suggests, is a discount to the subsequent raise. So, for example, a 10% discount would mean that if you put in $100,000 today, and then there's a future raise and it's at a specified price of $10 per share, for example, you're getting a 10% discount. You're going to convert as if it was $9 a share, to use some simple examples. So again, rewarding investors for putting in money earlier in the life cycle of the company to support growth. So those are very common features. And then once the company graduates from this kind of seed round, they begin to think about a series financing, which is the next stage of the life cycle for most of these companies.
I have a couple of questions on that topic, something that I've seen often in the Valley here. Number one is, what happens in terms of a convertible note? There's always a timeline, 2 years or so. If they are not able to raise the next round of money, what usually happens then?
It's a great question. I think in reality, the investor, who hopefully is someone who has some other connection to the business as well, right? Meaning they know the founder or they feel very connected to the mission, will be reasonable in the sense that there'll be a renegotiation. So there's one thing to say, if you don't pay within this particular time period, I'm going to seek to foreclose, which they may have the legal ability to do. And then what happens in reality? And so I think, at least in our experience, if you find yourself in that situation, it's often a situation where you're renegotiating, but that does require some foresight on the part of the founder. What you don't want to do as the founder, and to use your example of a 2-year maturity date, show up after a year and 11 months and say, gosh, I have a problem. How can we renegotiate it? That's a much earlier conversation. And being able to have alternatives to try to solve for that, whether it's raising capital from someone else in the form of a SAFE or a different convertible note that can pay off the original, right? You want to have options. And so having some foresight. But in reality, we often see that the investors are willing to have some flexibility and renegotiate, perhaps at better economic terms for them, assuming the company succeeds thereafter.
Communication is key in this. And then I think this is the complaint I hear from angel investors, that founders don't keep them updated. A big red flag and shouldn't do that. And another related question I have on this subject is some founders tend to change the valuation in the middle of a round, even if it's a seed round. What are the pros and cons of that? Any mistakes that you have seen in this?
I think it can be helpful to have a consistent narrative during a funding round around valuation where it's possible. Obviously, dynamics can change. So for companies in the deep tech sector, they're often looking at what else is going on in the world, right, with larger companies, public companies even. And so there certainly can be changes in the industry overall that can result in a change in the valuation, meaning normally some positive development, hopefully some positive development that allows for the founder to maybe look for a little bit more. As it relates to changes for deal-specific reasons or company-specific reasons, sometimes those are inevitable. Sometimes there just isn't sufficient investor appetite at a given valuation. Sometimes the founder and the other managers believe that the business is farther along on progress, whether that's scientific progress, medical research progress, or the like, than others view, and they need to correct themselves. But what I guess my general suggestion on that is you need to be realistic and listen to the investors and have a conversation and really approach it from the perspective of what kind of capital do I need now and what can be offered by the investors, and try to control that as much as you can, right? So if you can prepare ahead of time, get some input, look at the other advisors around the business and get a sense of the valuation that you feel pretty good about, then try to stay firm on that and try to get close to that valuation. And if you need to be pushed back a little bit on the valuation because the investors believe that there's some additional hurdles you need to clear, then think about whether that makes sense to you. And it may make sense, but are there other things you can do? Like maybe you do a little bit smaller raise that valuation with an opportunity to come back to the market later. But I guess a long-winded answer, but my general suggestion is to try to do enough planning up ahead of time, right, to be able to get a good sense of valuation. Try to be firm, but if ultimately the valuation changes because of market dynamics or transaction-specific dynamics, then you have to go with it. But don't just move back and forth because you can lose credibility and that can be damaging, not only for the capital raise, but thereafter.
Yeah. And speaking of valuation, maybe, and Amanda, you can talk about this. How does one, when you go into the next round of funding like this, you're going to value the company at a certain dollar figure. How does that work? Who sets this valuation price for a company? And tell us more about that process.
Sure. So why don't I speak to the 409A valuation,
Sure. Yeah.
which is in my universe, and then Nick, you can speak
great.
to the technicalities of the other valuation. And they're two very different things. 409A valuation is what sets the exercise price of a stock option, and it is used only for that purpose. It's driven by Section 409A of the tax code, which was concerned with many things, but some listeners may remember the option backdating scandals early 2000s. And the concern was options with an exercise price that was too low, that didn't reflect the true fair market value of a share of common stock. So 409A comes along. There's some precursors that also dealt with option valuation, but it sets forth the methodology by which a company should determine the exercise price of a stock option. The market practice today, far and away, the most common practice is to get a third-party 409A valuation. Most of the electronic platforms for managing the stock option grants in the cap table, I think we all know who those are. They'll usually provide these valuations, various methodologies. They look at some market data, many discounts are applied, and you come up with a number that is the exercise price for stock options. Usually these valuations are good for a year. So any stock options granted within that year have that price from the valuation. Once the valuation expires, a new one should be obtained. That is when I'm looking at a startup, either, diligence, maybe because an investor is coming in, or in a M&A deal. Majority of the problems we see with equity awards relate to these valuations and setting the exercise price of an option. So really important to focus on that. Again, good counsel will walk you through that. Will tell you some nuances with the valuations. For example, what happens if you're 6 months into this 1 year period I mentioned, and you get a term sheet for a Series A round? Is your valuation still good? And when does it go stale? Is it stale when you close the round? Is it stale when you have a final term sheet? And all very nuanced and technical, but a lot of future problems can result if you get that wrong. So that's the 409A valuation. And like I said, it's heavily discounted. It only serves one purpose. So I will kick it back to Nick under the theory that the valuation of the company in a round is a very different thought process and a very different number, typically.
Yeah, it is. I agree with that, Amanda. And I think I would maybe distinguish between real early rounds, so seed rounds, Series A round, maybe even a Series B round, and future rounds. And I guess just to pause for a second and make sure all our listeners are on the same page. When we think about financing for a company, seed round, as I mentioned, is really friends and family, a couple early investors. And then as institutional capital comes in, venture capital funding, for example, or including corporate venture capital, we are often talking about a series financing, and those are labeled alphabetically. So Series A followed by Series B, et cetera. In those early rounds, a lot of it is more a discussion between the company and one or two, I really should say, lead investors. Those investors could be venture capital funds, or they could be a strategic, depending on the nature of the business. But in that case, the business is often so early that a lot of the valuation is really from the perspective of the investor. What do I think about this addressable market? Do I think that, in fact, the entrepreneur has identified a need in the market that could be addressed commercially? What do I think about this particular entrepreneur and his or her team around them to be able to actually act on this? And where there are competitors, how do I think about this opportunity relative to other opportunities? And at the point where the outside investor can kind of clear through those different hurdles, I think the reality is they take the amount of capital that's being requested by the founder and company, and they'll compare it to data points that they have for other transactions they've made and more public data. And they may often just include in a term sheet a number that makes sense with reference to what they are going to purchase. So as a concrete example, it's not uncommon as we think about a Series A for the lead investor and the other follow-along investors to want to have about 20% of the business when the transaction is complete. So they may come in and say, I'm prepared to give you $5 million and I want to own 20% of the company. And that would be reflected in the term sheet. And so as we see terms like post-money valuation and pre-money valuation and how those flow through, those are a function of the math. So just sticking with that example, someone says, I'm going to give you $5 million. I'm going to own 20% of the company. To figure out what is our post-money valuation, meaning the valuation after that new capital comes in, we take the $5 million, we're going to divide it by 20%, we get $25 million. So in that situation, if that transaction proceeds and exactly as described, there'll be a post-money valuation of $25 million. Pre-money valuation, that term is indicative of what happened before that capital comes in. There we can do the opposite math. We can say, well, with a $25 million post-money valuation, they put in $5 million, so the business was worth $20 million on a pre-money basis. And there are different ways to compute and think about that. But at a high level, that's an example of how the valuation works. And I think in our experience, that's generally how it happens for the earlier round financing. So say a seed round, a Series A kind of financing. And then after that, it's a function of, okay, now the company has had an opportunity to take that capital and actually begin to progress the technology. What progress have they made as between when that capital came in and the next round of financing? And the investors, both the current investors who often look to and consider participating in a subsequent round, as well as new investors who may be coming in a subsequent round, are going to be looking at that progress and also comparing it against others in the industry and others that are in that life cycle, say from a Series A to Series B. And thinking about what's that incremental value that the company has delivered? How does that compare to my general experience? And are there any indicators yet that can help me map this type of business on any kind of valuation framework relative to other industry peers. And that's going to depend on the business. In certain cases, you may be able to look at a business that actually has not only a prototype, but actually has a product, right? And they're beginning to get a contract or two or a customer, right? And they can begin to use those metrics and say, okay, well, if I look at that and I project out in the future based on the company's growth rate, then I think this is how the business will transform over the next 12 to 18 months. And here's what I'm prepared to invest on that projection. Other businesses are just so capital intensive that it's really hard to make meaningful progress. And so it's a bit more speculative in that sense, right? It's a bit more a bet on the vision and a bet on the technology. But there becomes a transition. It's a gray area, a transition between a bit of this science of, okay, here are actual statistics, KPIs, key performance indicators of the business. I'm going to apply them in a framework where I can actually do a valuation model versus art, right? And the art is often very prevalent at the early stages, and that can be extended depending on the nature of the business and how capital intensive it is. And there's no right answer, but there is this transition from art more into science, into science, into science, and then becomes a bit more as the company grows, and now they're doing a Series C or a Series D, where investors are looking at the prior rounds and the success of the business and the financial statements, but also other private company peers, public company peers, if they exist, and considering things like a discounted cash flow model, if that makes sense for the business, applying a key performance indicator of that business against a metric that applies in the market, whether that's on revenue per user or whatever it may be based on the specific industry. So it's a squishy question, a squishy point around valuation, but it's a blend of art and science. And I think it transitions from art more into science as the company grows.
It is indeed a blend of art and science. Thank you for delving into that topic. And one problem that comes up again and again with founders, I would call it a problem because they're very contentious about valuations of what they think the company is worth. And I hear in many cases that, over the long period, it doesn't really matter if you focus on the product and the market and so on and on. What are the common mistakes that people do that you have seen, that one or two, if you can mention, that they should not get stuck on and keep moving forward?
Yeah, I'd be happy to. So I think one thing to think about, which is maybe particularly relevant for companies that are in the current market environment, maybe a listener who already has a business, maybe they've done a seed round, they're focused a bit on valuation, but it's a reality that the financing markets are a bit tighter now than they were in prior years, particularly as we think about some of the successes of the market in 2021. And that is focusing around what people think of as a down round, right? So a down round meaning I raised capital at a particular valuation, and if I raise capital again at a subsequent date, based on the indicators that I have so far, I'll be at a lower valuation. And that's considered to be a down round. I think one of the potential traps is to be so focused on the down round that you don't view it as a stop along the road to success for the business to get the capital you need. And instead, you focus so much on the down round that you don't take the capital and you can impair the business. The reality is that most entrepreneurs who are starting this business are in it for the medium to long term. They have a really great vision for their business, and they're capital intensive, and they need capital. And so when you are reaching a point where you think you're going to need capital to continue to grow the business, you don't want to stall the technological progress, the scientific progress that may be applicable. You need to come up with a creative way to get that capital. And rather than just turn away from a valuation that you don't like and not do a financing and lose valuable time and progress, think about, well, can I take a little bit less capital at that valuation? Or is there something else I can do? Can I explore some alternative arrangement with the investor? Maybe I can trade for them. I can give them a little bit more control over my budget, or a little bit more information, or a little bit more control over the vision in exchange for the valuation, right? So what can I trade in terms of economics versus contractual rights that might help move the needle? But I think one takeaway is try not to be so focused on valuation that the business suffers because you're afraid to take the capital. And then the second point I would say, which also relates to valuation, is as the company begins to grow, try to focus on what the end goal of the founder and business is, right? That for some businesses, that could be a sale. For some businesses, that could be an IPO. And so try to stay focused on that goal. And if in the interim, you're doing a valuation and maybe you thought it was X and someone else thinks it's 90% of X, right? Again, I would go back to that point. Well, what are we trying to achieve? How can we utilize this capital to get to our end result? Because if you focus on your goal, okay, I'd like to do an IPO, I'd like to do a sale, that's when that valuation really crystallizes for many founders, particularly in the case of a sale, but also from certain perspectives in the case of an IPO. And so if you again think about it as a little bit of a bump in the road, but I'm on to bigger and better things, and I think that could be helpful. And if you look in the current news, there are many examples of highly successful, large private businesses that have recently announced financing rounds that are either not a significant increase in the valuation from prior rounds or potentially even a down round, but in my view have made the right decision to take that capital to grow the business and focus on that bigger goal down the road, a sale or an IPO.
Great. Thank you for that. Let's shift the gears here and talk about factors that founders should keep in mind as they interact with investors. What should a founder look out for when they bring on an investor in terms of terms they should scrutinize and or avoid? Any light on that would be helpful.
I guess a couple of things that are quite commonly negotiated that I'd like to bring to the listeners' attention. The first is really around board seats. So now we're talking about a business that is not a true startup now, but they've got some advisors around them. And I think they want to be thinking around who are the other decision makers in this business. It's no longer just me as the founder, and have an expectation that lead investors are going to want a board seat, meaning a directorship, and also potentially an observer seat. So an observer is someone who doesn't have a voting right at the board of directors, but nonetheless sits there and has certain information rights. And there are different ways to think about that depending on the size of the investment, the investor, right? Certain investors may want a board seat. Some may want both. Some are happy with an observer seat, but that's someone else in the boardroom. And you want to plan around that. And one thing to think about, going back to our earlier discussion, is, okay, when I'm looking ahead, I'm eventually going to have to add a couple different board members. What can I do to surround myself with people who are supportive of the message and the vision so that I have other board members to help balance out and help maintain the vision of the company, but also to have some input, right? And have a conversation with those investors. Different investors bring different expertise to the table, and so do their director nominees. And so if you are a company that needs maybe a little bit more technical expertise, think about an investor that can bring a director that has that. Alternatively, maybe you have all the technical expertise you need in-house. What you really need is someone who can help bring some accounting skills or some marketing skills, right? So think about that kind of mix. But you should expect that an investor is going to look to have a board seat. You would expect to have the investors to have some type of rights with respect to future issuances of shares. So a right of first offer is fairly common. A right of first offer says if the company goes to issue new shares, then they're first going to look to those specified investors and say, would you instead like to buy the shares at this particular price? And of course, the existing investor can decide they want to pass, but knowing that that's going to be coming as an expected right helps you plan as you think about your future fundraising. As it relates to transferability of shares between different holders, it's quite often the case that investors that are coming in, at least significant investors, will want to have what's referred to as a right of first refusal. So if Amanda and I are both shareholders in the company and I'm a major shareholder because I'm leading the round and I have a right of first refusal, that means that if Amanda is looking to sell her shares to someone else, she's going to notify me and I'm going to have the opportunity to buy that share before she sells it in the open market. And there are different ways to negotiate that. In certain cases, the business will be able to negotiate to have the company have a right of first refusal, right? Which can be a way to help manage the dilution a bit. Obviously, it requires that the company have access to capital to fund a purchase price, but at least it means that if an investor is looking to transfer their shares to a third party, and maybe the company is less than overly enthusiastic about that third party coming into the capital structure, for any number of reasons, they might be interested in just buying the share, buying out the investor. And then there's going to be a couple different rights that relate to exits. So pause on those for a second. Two very common rights to be familiar with are tag-along rights and drag-along rights. And I think if you're trying to visualize this, you can imagine someone's trying to run with their shares toward an M&A transaction, sale transaction, right? So a tag-along is the other shareholders, a majority of the shareholders or certain specified holders are looking to cause the company to be sold as part of an exit event. Tag along means I'm going to grab on to that person's hand. They're going to tag along to that sale. And so if those individuals have the opportunity to sell their shares at a specified price, I, as an investor, also have the right to tag along, to participate and have my shares sold at that price. Drag along is from the opposite perspective. Drag along is from the perspective of someone who may have significant interest, significant economic interest in the business, is looking to sell the business. In many cases, that's going to be in combination with the founder, unless they've been significantly diluted at that point. And if they're looking to sell the business, their ability to sell may be impaired somewhat if there are people that are left behind, other old shareholders who are left behind. And so drag along is the ability to tell those other smaller shareholders, we believe we've negotiated this great transaction, the board has approved, et cetera, et cetera. You essentially are forced to sell your shares. And so a large investor would like to participate and have the ability to require a drag, require all the shareholders to come along if the criteria is satisfied. So that's in the context of M&A. Then in the context of an IPO or some other go public transaction, there will be rights for the investor to have their shares be able to be sold in the public markets. And that comes in different flavors that can be a bit complex quickly. But at a basic level, listeners should understand when you're dealing with public offerings of securities, IPOs, it's a complicated process. It involves the SEC, which is the Securities and Exchange Commission, a regulatory body in Washington, and you have to file various documents with the SEC. So registration rights and related rights in the context of an IPO are rights that an investor says, okay, you can go do your IPO company, but in certain situations, I might be able to participate in the IPO by selling some of my shares. Or even if I don't participate in the IPO, at sometime in the future, 6 months, for example, after you've been a public company, you're going to help me do the paperwork necessary with the SEC to be able to sell my shares in the public. So that's quite common. So circling back, the last bucket are really around consent rights. So on the corporate side, I would expect that large investors would have a list of things that they would like to have a veto power over. That would include significant transactions like an IPO, like a sale of the company, incurrence of debt above a certain level, change in the strategy. And then it also relates to certain changes of management, certain changes in the equity plan. And maybe Amanda, you can pick it up there.
Sure. Yes. The equity plan, we talked earlier about this 10 to 15% pool. Usually that will expand in one of these later rounds, Series B, C. So important to work closely with the investor on that. As I mentioned, you need enough headroom there to make your hires and to compensate future hires and even existing employees. I guess one other minor point, sometimes when the investor, when the nature of the investment is such that maybe a professional CEO will be brought in, maybe a founder will be pushed out of a day-to-day role. Sometimes there's some thought around severance. And, maybe not cash severance, but what happens to unvested equity if this person is more or less pushed out of their day-to-day role. So good to get out ahead of that. Two more material points to make. First is revesting, or I've sometimes heard it referred to as reverse vesting. As we talked about, those founder shares, the restricted stock, a 4-year vesting schedule is very common. Let's say Series C, perhaps we're at year 5, year 6, those shares are vested. Founder thinks they can leave and keep their shares. Often these investors will ask that those shares be subject to a new vesting schedule. So they revest and another 2-year or 4-year vesting schedule is applied to those really as a retention tool to keep those people around for the longer term. Again, it's probably not every transaction, but we see it. Something to be aware of. The tax consequences, the economic consequences don't change much. But again, it's the somewhat unfortunate situation of having to work another 4 years to earn those shares. So that's one to think about. Secondary sales sometimes arise in these rounds, and that's where a founder sells shares either directly to the investor, sometimes to the company. That happens for a variety of reasons. Sometimes it's things are far enough along, 1 or 2 or more founders really need an opportunity for some liquidity. So that sale is negotiated. Other times the investor might need those shares to reach a certain percentage that they're looking for. So the shares are purchased. And I mention it only because there can be some strange tax consequences for the founder, depending on how the shares are sold and the price that they're sold for. So something to look out for. We don't need to get into the technicalities, but I've seen a lot of founders surprised at the last minute in one of these secondary transactions.
I think the secondary point is actually a really good one to raise also on the corporate side, because as may be obvious, may not be obvious to listeners, there are two primary ways where we're thinking about getting shares in the hands of investors. Primary meaning that the company itself is issuing the shares and receiving cash, and secondary meaning one of the current shareholders, which could be the founder, selling the shares. And all things being equal, investors prefer primary, right? Because they want to see the business grow. And so every dollar that they put in that's in a primary goes directly into the business and gets invested and goes into technology, et cetera. Whereas a secondary, that's money that goes to a current shareholder and doesn't go into the business. And so it is certainly appropriate for a founder to think about, in the context of negotiations in later rounds, whether it makes sense for them to have a little bit of liquidity, exactly as Amanda described, but do recognize also that you need to be realistic and understand that investors' expectations is that that money is really designed to go for the company's growth. And so it's a balancing act. And obviously, the longer the founder has gone without significant liquidity or significant cash, salary, whatever it may be, then the easier the case he or she can make to try to have some liquidity as part of those rounds.
Yeah, and it's really not a bad thing, the secondary. Sometimes these founders spend about 5, 10, 15 years, like they're still far off from the market, and like getting some liquidity is actually a good thing for these people. Mm-hmm. Something to think about, I think. You covered a lot of ground about the founders and the investors. Amanda, I want to make sure we cover the employees. A lot of the scientists are going to be becoming employees. Like, how does a founder, if you want to do the right by the employees, safeguard their equity portion of it? Because sometimes they can't afford to buy those RSUs out, and there are huge taxes that will come. What are things they can do?
It's complicated. So you mentioned RSUs and on the theme of dilution. At some point, and at these stages that we're talking about, where the rounds get more complex, that's often where you will see a shift from options, from a company that grants options to granting RSUs. I mentioned earlier valuation. Again, these option exercise prices. If you're paying $100 per option, that's both optics and economics. That feels like a lot. That option doesn't feel valuable, perhaps, if you receive an option agreement with a $100 or $200 strike price. Also, dilution. Given the nature of these awards, an RSU is often less dilutive than an option, in the sense that fewer RSUs are, all else equal, you grant fewer RSUs than options. So we do see that switch. The way a private company typically structures an RSU is with two vesting conditions. There's the time-based vesting condition that we've been talking about. You have to work for a year to earn 25% of the award, and then maybe monthly thereafter over typically 4 years. Often, particularly in the technology, life sciences space, there is a second vesting condition layered on, which is a liquidity event, an IPO or IPO-like transaction or an M&A event. And structured properly, that allows deferral of the tax until this IPO or sale event happens. So it can be helpful. Again, you're not facing this $400,000 tax bill that I mentioned when the company is private and someone's frankly liquidating their personal brokerage account to pay the taxes. You can delay the tax until that liquidity event. I would say they're, very complex instruments. There are timeframes that you have to layer onto that, but we see that a lot. And that's a nice way to perhaps avoid these upfront payments without liquidity.
Another thing the founder could think about for providing some liquidity to employees more as the company progresses, not at a real early stage, is a tender offer. So a tender offer refers to the company making an offer to some specified universe. It could be employees, it could be former employees, it could be both, it could be certain specified group of persons, and offer to buy back the securities at a specified price. And there's some mechanics around there that are important to make sure one gets right from a legal perspective. So it's something that requires close coordination. And you also want to be cognizant of the price that you're offering, and both from a legal perspective, but also so you feel like and your employees feel like you're doing right by them. And so it's often coinciding with a capital raise. So there's a third-party investor who says, I'm prepared to pay $12 per share, and then that becomes, give or take, your offer price. But that can be an option that can be considered, and particularly for a company that perhaps thought that they might be acquired earlier than turned out to be the case, and they're going to go out and seek some additional capital. Combining that capital raise with a tender offer can be a nice way to reward employees. And the nice thing about the tender offer, one nice thing about the tender offer is that the holder of the share, the employee, gets to choose whether to participate or not. So you may have a universe of people who, some they're in it for the long term, maybe they have enough cash saved up that they want to have the upside and they don't need the cash right now and they can enjoy that upside by holding on to it. And others who really need the cash or want some cash. And so by giving some flexibility to the employees, that can be a nice tool. And we certainly see private companies, when they get some years behind them, considering that option.
This has been very, very helpful for me, and I'm sure my audience is going to appreciate this. Before the closing, any words of wisdom, parting words of wisdom for founders, both of you?
I think on my side, I would go back to a point that I believe Amanda made toward the beginning, which is try to be thoughtful about what your future business looks like and what are the planning steps that make sense now. That's in terms of the providers you're surrounding yourself with, but it also covers some of the other topics that we covered today. Who are the types of investors who are going to come in the early round? Who are the types of investors that are going to come in later? Who are the directors that you'd like to have on your board? So as much as possible, try to not face each individual decision as something that needs to be solved today. Okay, I need capital right now. Okay, I need to have this director appointed right now, and view them as one-off transactions. Try to view them with a little bit more foresight as to what your near and medium terms are for the business, so that those kinds of decisions can be made in the best interest of the founder, but also of the business as it seeks to grow.
Long-term thinking. Great advice. Yeah.
My takeaway is careful documentation. So we talked earlier about taxes and rates, ordinary income rates versus cap gains rates, et cetera, driving a lot of the decisions around equity comp. In the tax world, and as I said, with the 83B election, there's a lot that cannot be fixed without proper documentation. So again, the 409A valuations, documenting stock option grants via proper corporate approvals. This is not something that the CFO should be promising in an email to their friend who's being hired. That is not a valid option grant. And there can be some very, very bad tax consequences down the road that we simply cannot fix if the formalities are not respected there.
Great advice. Again, documentation, long-term thinking and documentation. I think these should be the fundamentals of any founder's thought process for a startup. Amanda and Nick, thank you so much for your time. I really hope we can do this again on other topics, but you're one of the best. Yes, for a reason.
Thank you. It's been a great honor. Thank you very much.
Thank you.
Thank you for listening to this episode of the Lab to Startup podcast. You can find links to the resources and programs mentioned in these episodes, connect with Naresh, or subscribe to this show at labtostartup.com.